I'm Howard Simon I'm the director of the American Civil Liberties Union of Florida, and I just want to introduce who's going to be here, who's available for questions. We have a legal team that has represented Martin for several years in this case, including Leslie Cooper, a lawyer with our National Lesbian Gay Rights Project in New York, Shelby Day of our staff, but based in our regional office in Tampa, as well as Randall Marshall, our legal director, and James Essex, the director of our LGBT project in New York, and Rob Rosenwald, a former member of the ACLU staff. In addition with us is Elliot Shirker and Bridget Check-Smalley, who have represented the children in the case. We have represented Martin Gill, and the attorneys from the Greenberg Traurig firm have represented the children involved in this case. I just want to say briefly, of course, we are thrilled about this opinion. A unanimous judgment with one judge signing on to his own concurring opinion. We're thrilled for Martin. We're thrilled for what this means for the advancement of human rights and equality in the state of Florida. We're thrilled for the current and the future families that will be that could have been impacted negatively by this law, and we're thrilled for the children who are now in Florida's troubled foster care system and who are in need of a permanent, loving, and stable home. I want to say we're thrilled by the decision that I read for the first time in the newspaper yesterday by the director of the Department of Children and Families, that whatever happens in this case and whatever happens in the future legal history of this case, the state has recognized what successful foster care parenting looks like, and that is the record, the impeccable and admirable record of Martin Gill. And whatever happens in the future history of this case, we're thrilled that the state is not going to break up this family and yank these children and even break up the two brothers in this case and put them up for adoption elsewhere. So we're heartened to hear that news. I just want to say one thing. This law has been on the books since 1977. It is struck down today by a unanimous District Court of Appeal. If it shows anything, it says the following to me. Given our terribly flawed, inept, public policy making legislative process in the state of Florida, it shows that it is really easy to enact a lousy law, and it takes years, if not decades, to remove a bad law from the books. And that happened now today. With that, I want to turn it over to the person whose case this really is, whose guts and whose fortitude and whose willingness to take on the state in this battle. We were heartened to simply assist in this effort, and that's Martin Gill.
Good afternoon. Thanks everyone for coming. First of all, I want to thank my lawyers. I want to thank the ACLU and Howard Simon, Rob Rosenwald, who was here through much of the case, Elliot Shirker, for all doing such a wonderful job. Certainly I could not have done this on my own, not economically nor the moral support that the ACLU has given us. Today, the Third District Court of Appeal affirmed the original decision by Judge Cindy Lederman on the grounds of equal protection of both gays and lesbians and the foster children. I'm very thrilled by the decision. I'm really thrilled that it was done on the grounds of equal protection, and not only on behalf of gays and lesbians, but on behalf of foster children. That it's nice to know that we're considered now amongst the rest of humanity, that we have the same rights. We still don't know exactly what this means. We don't know if the state's going to bring an appeal. But at least for today, the law, this egregious, arcane law that has been on the books for 33 years is gone. Hopefully it will stay gone. We are committed to keeping our family together, and regardless of whether the state appeals, we're committed to doing whatever we need to do to keep our family together. About 13 months ago, we were in an oral appeal, in a hearing for the oral appeal, and Timothy Osterhaus, an attorney for the state, was asked what would be the final disposition of the kids. Would they be allowed to stay with our family? To that he responded, no, they would immediately seek a court order to remove them from our family and put them up for adoption. So for the last 13 months, we have lived week by week with the fear that on any given Wednesday those kids could be taken away from us. We're the only family that they remember, the only family that they know. They would be taken away not only from us, but from their teachers, their friends, their aunts, their uncles, their pet dog, and their grandparents. They would be taken away from the entire life that they've built over the last 5.5 years. Yesterday, George Sheldon came out and said that that was not the intention of the Department of Children and Families, and for that I'm grateful. For that I've been really relieved. Today is even more of a relief. To know that all 3 judges were unanimous in their decision is really heartening. My boys are now happy, healthy, thriving, and my little one is now 6 years old. He came to us at 4 months. My older son is 10 years old. He came to us at 4 years. They're both doing well socially, just on about everything you can imagine. They're thriving by all accounts. We've grown to love these children. In return, they've inspired us. We've learned a great deal from our kids. I think it's important to point out that the state still has over 19,000 children in foster care. There are, at the time that this case was first tried, there were 3,535 children waiting in the state of Florida for adoption. The ban on adoption does nothing but lessen the pool of potentially good adoptive parents. Again, for those who have concerns out there, we've never fought that every gay and lesbian parent could adopt. What we've been fighting for is that we would level the playing field and that each judge could make that individual determination on who's a fit parent. There's one thing I believe, and that's that every child deserves a family, regardless of what background they come from, regardless of how long they've been in the foster care system. And I think today is a big step in attacking that problem. I think that the number of gays and lesbians out there can really make a difference. And studies have shown that gays and lesbians are willing to adopt children with disabilities, adopt children of color, adopt children who for years have been turned away from adoption by other eligible parents. Along the way, I was told, well, you can't fight the law. Well, we have. After 33 years, this law is going away. But I'll tell you, I couldn't have done it except for my kids. It's amazing what a parent will do for their children.
For whoever can answer this, can you explain to us lay people how this case will affect others, not only in appeal in the courts right now, but maybe before a possible appeal to the state's appeal?
Yeah, I'm Randall Marshall. I'm the legal director for the ACLU of Florida. The District Court of Appeals decision today, once it becomes final, is binding upon every circuit court in the state of Florida, meaning that any other adoption has to be considered on the merits of the individual seeking to adopt, and this statute is not to come into play and is unconstitutional.
Are you expecting an appeal? I mean, what is your sense of that?
Well, First off, it's not our decision to make.
No, I
obviously,
understand that. Given the atmosphere, what is your expectation?
At this point, we don't have an expectation. I would like to ask Elliot to talk, because I think Elliot has a good take on the situation here too.
Can I just follow up before you do
Oh,
that?
sure.
So when you said when it becomes final, does that mean you wait for the expiration for a possible appeal?
Yes, the state has 30 days in which to file a notice of appeal, and so that decision won't be made today, tomorrow, or next week, perhaps.
So tomorrow is the same as today.
Yeah.
We're waiting for 30 days.
Yes, that's right. Until it doesn't become final until the expiration of that time.
Well, actually, we're waiting for 15 days.
Okay, sorry. Go ahead.
We're waiting how many?
We're waiting for 15 days. My name's Elliot Shirker. My colleague Bridget Check and I represented the children on the appeal. The indispensable leader of our team, Hillary Bass, is unfortunately out of town today. She should be standing here with us and answering these questions, because she tried the case for the children and helped the ACLU assemble that incredible record that you see detailed in the opinion. The short answer to the question is 15 days from the date of this opinion, as it says on the first page. If there's no motion for rehearing by the state, the decision will become final. Another 15 days needs to pass before the state's appeal time expires. But the decision will be final in 15 days if there's no rehearing. And to pick up on what Randall was talking about, Judge Salter, in his opinion, dropped a footnote acknowledging what Judge Cope, the lead author of the lead opinion, said, which is noting that the state has the right to appeal, and suggesting that perhaps the state might want to consider not, so that this family can end the uncertainty with which they've lived for so long. And I think Judge Salter's wisdom should be taken seriously by anyone thinking about whether to appeal.
How many states currently have a ban, and what do you see as the ramifications beyond the state of Florida?
Florida is the only state with a statutory ban that we know of. Certainly at the time we did this appeal, it was the only state with a complete statutory ban.
There are some states that have some permutation of this, like no adoptions in a household in which a gay person lives. And there's some confusion about this, even understanding the Florida law, or no adoptions by gay couples. Florida's ban is a ban on an adoption by a gay person, and we're the only state that has that kind of ban on an adoption by a gay individual. It's not a ban on couples.
Well, how then does the Cox case, which sort of is open-ended, is there an effect of that case on this, or does this supersede that?
The Cox decision was what left the door open for this litigation, to bring an equal protection challenge under Florida's Constitution. And that's the basis for the ruling today, is that the statute violates Florida's Equal Protection Clause. The court found quite convincingly that there is no factual support, there is no scientific evidence to support any categorical ban on adoptions by gay men or lesbians in Florida, that on a case-by-case basis, they are equally capable of being good, loving, nurturing parents. And Martin Gill, of course, is Exhibit A in being as good a parent as one could hope to find in the state of Florida.
Given that, and even with the legal differences from here to other states, do you see this being broad enough, powerful enough, sweeping enough to knock down some of the barriers that you described that exist in other states? Not quite the same statutorily, but what impact do you see? Well, certainly,
this decision, I think, would be a clear signal to any other state that would even consider trying to implement this kind of a ban, that there's no reason to go there, that it's clear, as I said, that all of the scientific evidence that was placed before Judge Lederman convincingly and overwhelmingly come to the same conclusion, that there is just simply no reason to have this kind of a ban. It makes no sense whatsoever, and it harms children at the same time.
So the legal tentacles are really kind of intriguing. Since this is an equal protection case, let's say the 15 days goes by or 30 days goes by, does this lifting of the ban now apply to the other cases that have been tried on different grounds other than equal protection?
I would, this is just hypothetically, I would think that if there are any cases where individuals were denied an opportunity to adopt a child under this statute, that those individuals might want to consider applying again, which might be the easiest way to bring the issue up. There's a lot of procedural issues involved in reopening old cases, and I wouldn't want to speak to that without looking at a specific case. But the law, when a law is declared unconstitutional, is declared unconstitutional in the Latin term ab initio, meaning from the day it was adopted. And so it's always, as of today, it's always been unconstitutional.
And so then what happens to this other case that's right now being considered by the third DCA? Vanessa Allen's case, the appeal was heard last 2 weeks ago?
That was one that was argued 2 weeks ago.
Yes.
I'd let you speak to that. Right.
It's somewhat of a difficult legal question, but if, for example, the state does not appeal, this decision becomes final, then it would seem, to the degree that the third DCA has not ruled on the other case, there's no reason to, because it's mooted out, because this law is unconstitutional and can't be applied. If the state were to file an appeal, then we would expect a decision out of the DCA on the other case, perhaps on different grounds.
The most important thing for me was to try and insulate the kids a little bit from the fact that at one point anyway we believed that they could be taken away at any time. And I think that could do no good. Any child knowing that they could be ripped away from the only family they know any given week would be horrible knowledge for them. So really we've tried to protect them from that as much as possible. With that said, they know that there's a case going on, and they know that there's an adoption case going on and that we're trying to adopt them. And you've probably heard this story, but I sat down with my kids about 3 years ago when we were going to court the very first time, and I explained to them what adoption meant. And at that time I think we're talking about a 7-year-old and his little brother was about 4. And so they weren't really getting it. But what I did was I took 3 pieces of paper, and I wrote my name down with my last name, Gill, and I wrote their names down with their new last names on it. And we sat down and we sat about writing those out. And I was writing with the little one because he didn't really know how to write now, and we were tracing through the letters. And the older one at first gave me this look like, what are you doing? I just learned to spell my name. But then, after he had written out about 3 of them, he said to me, Poppy, we're all going to have the same last names now, and that's what's going to make us a family. And at that moment, it really got to me. It really got to me that he did understand at least that particular part of an adoption was very important to him, and he got it. A half an hour later, he was still writing his new name out. He went through 3 pieces of paper and just kept going and just looked as happy as could be. So they have some concept of what's at stake here. It's been disappointing each year since then. I've had to bring them to school and register them with their old last names, and we all have different last names. And then I generally have to explain to the teacher that I'm their guardian, not their parent. And now, hopefully, this will have been the last year that I have to do that.
Martin, there have been a lot of Wednesday mornings since that appeal.
A lot.
It's
been a very tough year.
Yeah. Can you sort of share with us today, this Wednesday morning, when you found out, how you found out, and what you did and what you said, and take us back there?
Yeah, well, it's been a year of kinds of pins and needles. Tuesday night and Wednesday mornings have been difficult for me. I think I was in a little bit of disbelief. It came out a couple of minutes beforehand, and Randall said he got the decision, and it's a good one, and I kind of thought he was joking. I just couldn't believe it. I was kind of awestruck. You're kidding me. It has been such a relief knowing that it was a unanimous decision, all 3 judges agreed, and that we won on the grounds of equal protection, not only for myself, but for my kids. Equal protection on the part of foster children. To me, that's just as important.
Did you tell them?
I haven't been able to tell them yet. They're in school. From there, it gets kind of complicated. What do you tell them? Are we going to get appealed? Is this going to go on? It's unclear exactly what this means to my kids. For me, my partner, and everybody in this room, I think it's a huge victory.
Maybe they'll go to law school.
They've certainly got more friends that are lawyers. And I don't know, how many lawyers do we have? Do you know? Last count?
6 on this case.
Takes a village.
Anyway, the ACLU has been wonderful. Greenberg Traurig, I can't say enough about. They've done an amazing job, and all along they haven't even really wanted their name in it. It's been great.